I will ask the council in 125283, State of Kansas versus Gina Wilson, to please come forward. All right.
May it please the court, Peter Meharry for Gina Wilson. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted. Thank you.
Thank you. This case is before this court on a petition from the Court of Appeals on one issue, and that is whether or not the search, or I should say the traffic stop, was measurably extended beyond the time necessary for the traffic stop to allow the officers to run a police dog around a vehicle that my client was driving. And it's our contention, and we believe the record supports this, it was measurably extended. It was measurably extended by about 4 minutes. And while that may not seem like a long time, it is something that is in the record and measurably extended in violation of my client's constitutional rights.
Counsel, can I stop you there and
Sure.
jump in with my first question, which is, let's just assume that you are correct, that the detention of your client was unconstitutionally extended. Why does that, or how does that impact the search?
That impacts the search because once she is improperly detained, she can't leave, but you have to look at it. Okay, we're doing the citation, we're done. Do we have any reason to extend the detention?
Right, well, I'm saying let's assume that you're correct about that. And let me give you a hint what I'm
Sure.
driving at here. She could not drive the vehicle. She
That is
did
correct.
not have a license. So she was unconstitutionally detained.
Correct.
But the car is legally parked on the street. It's not, they're not detaining the car, are they? And a drug sniff is not even a search. I mean, they don't even need, so let's say they hadn't detained her and she walked away, and then all the other facts are exactly identical. How is the search unconstitutional?
The search is still unconstitutional because she was detained so that she could not, theoretically, if she was not detained, she could have went to her car, grabbed her belongings and left. She maybe not could have driven because she admittedly had a suspended license. They warned her, we don't let people just drive away when they have suspended license, but she could have grabbed her stuff and gone. Alternatively, she could have had somebody come get it. Now, timing wise, this court may not think that works, but had she been free to go, she could have grabbed her stuff, or she could have called somebody to get the car such that the search would not have occurred. She was not able to do that because she was in handcuffs at that point, and she was unconstitutionally detained. So we don't believe, and the district court did talk about inevitable discovery, which is where I think you're kind of going. Court of Appeals did not, because they did not find any constitutional violation. But we don't think that there was inevitable discovery to save this search, because from her standpoint, she was unable to leave, unable to grab her things. She was there looking at a rental property. That's why she pulled over. But she couldn't grab her stuff and go look at the rental property because she was in handcuffs.
But she was lawfully arrested, correct?
I would argue she was not lawfully arrested. She was only arrested after the dog hit, and we believe that is after an illegal detention. Like I said, she should have been free to go.
But there was probable cause that she was driving while suspended. Was that not an arrestable offense?
I believe it can be, but maybe I'm wrong on the record, but I believe the officer wasn't going to arrest her for that. My understanding is they decided to arrest her when the dog hit. It wasn't the driving while suspended that was going to get her arrested. It was a hit on the car from the dog. So even though she had a driving while suspended, I think the testimony was they warned people, don't go drive anymore, get it taken care of, whatever. But it's completely within my understanding the officer's discretion whether or not to arrest. And he wasn't arresting her for driving while suspended. He was arresting her because of the dog hit.
Do you think the district court findings, though, constrain your argument? I'm taking you back, I think, to Justice Deagle's questions about the connection between the detention and the search, and maybe it's inevitable discovery and attenuation. I'm not sure what you call it, but the district court is making findings, it appears to me, about the timing and the sequencing of these events to where your hypotheticals of her, maybe she could have grabbed the stuff and left. It doesn't comport with the timing according to the findings of the district court, does it?
Well, I think as far as the timing goes, she should have been allowed to leave. And I don't think there's anything to say that she couldn't have grabbed her stuff out of her car and walked away.
But is there any testimony in the record to that effect, that that was her intention, or
I think the
is
only
it purely just kind of the hypothetical?
For the most part, it is a hypothetical, but the state has the burden here, I think, to prove everything was constitutional and proper. But also, there was testimony that I think it's actually in the videos that, you know, they asked her, did you want somebody to come pick the car up? She certainly said yes. I don't think it was her intention. I think you can glean from that she just wanted to leave her car there, just abandon it. So I think the district court's findings as to timing said, look, the dog was there. But again, that still doesn't preclude her from going into her car, getting her stuff and leaving.
Let me stop you on that. I mean, I'm sympathetic. There's no reason why she wasn't allowed to leave. Let's just assume that. So now we've got two alternatives. One is she just walks away. I can go there. But now you want to, the dog's there. So if you're waiting for somebody to come and pick up the car, the dog's going to alert. So I don't think that path gets you anywhere unless, I mean, you can correct me, but I'm kind of ruling that out. But now you've got that she could take her belongings. So let's go down that path. If they're letting her in the car and she's grabbing bags, an officer ought to be allowed to be around for that, to make sure she doesn't, you know, for officer safety reasons. I don't think they have to stand aside and let her freely get whatever she wants and the dog's there. So it just seems like, getting back to Justice Wall's point, it just seems like the facts don't quite work for your alternative paths, other than she could have walked away. And if she's walking away, there's a car there and the dog's there and the dog's going to alert. That's the way I'm looking at it. Now, push back on that.
Sure. I guess two things. Number one, as far as her being allowed, if she is free to go, she should be free to go to her car and grab whatever she wants. Officers there are not. Either she's free to go or not. So if it's her car, her things, and she's free to go, she can go into her car and get what she wants. I don't think saying, well, the officer wouldn't let her in the car. That's not a crime scene. Nobody's saying it's a crime scene.
No,
They have no
just have to
basis for it.
stand there while she's getting her stuff. And if they're standing there while she's getting her stuff, there's a drug dog there.
Sure. But that's not meaning that the drug dog is up there sniffing around her. If she's going into her car to get her stuff, she should be able to do that regardless of what the police are doing. Second, just because the drug dog is there doesn't mean the officers would have searched. Maybe they would have, maybe they wouldn't. I don't think there was testimony as to what they would have done had she walked away and the car was left there. I think the inference that the state wants you to drive, of course they would have searched it. They were already there. But I don't think the record necessarily shows that. But most importantly, if she is free to go, which she should have been, she can do whatever she wants with her car. I mean, she could have drove it away. Not a smart move. But if she's free to go, she can do what she wants.
They would have just arrested her.
Like I said, not a good move. But she has to be free to go. And you can't say, well, she's free to go, but we're putting all these restraints on her. That's not free to go.
Well, but now you do have an additional fact besides the traffic violation for which they stopped. Now they have the fact that she's got a suspended license. So what effect does that have on whether or not the stop can be extended past what would have been constitutional for the traffic violation? Anything?
I don't think the driving while suspended does anything. The officer said, I think the citation was gonna have both driving while suspended and failure to failure to use turn signal. And he testified, I was done writing up the citation roughly the same time the drug dog got there. So I don't think that itself allows the officers to extend it, because they weren't gonna arrest her for driving while suspended. They only put her in cuffs after the dog hit on the car.
Didn't they have to figure out what to do because of the suspended license?
They were writing a ticket. I mean, that's what they were doing. As
As I
far as,
understand under the facts, they were talking to her about, we're not going to be able to let you drive away now because of your suspended license.
sure,
Are you going, what are your plans? Are you going to have somebody come and pick you up? They were explaining that to her. So that's going to take a little bit of time. And you would agree that that time would be a legitimate extension of the stop, right?
except in this case, the officer testified he was done with the citation, which was for the failure to use turn signal and driving while suspended, roughly the same time the drug dog got there, but several minutes before the drug dog hit. So they
Okay.
were not extending the stop because they were trying to figure out what to do because of the driving while suspended. They were extending the stop so that they could run the drug dog around the car. And as far as what to do, this is on the video. They asked her, and this is after she's handcuffed and put in the car, do you want somebody to come pick up your car? And she said yes. So I don't think the driving while suspended in any way extends it to save this search.
I have a note that at record volume 4, page 24, the officers testified that they always intended to arrest her once they asked her to exit the vehicle, as an arrest would provide another way for them to accomplish their ultimate goal of searching the vehicle for drugs. So, and I'm not, I may, that note may be incorrect, but just assume with me for a second that it is correct. And how does that impact your argument? What would your argument be under that scenario?
Well, if that is true, that they were going to arrest her for the driving while suspended, I think that does change things. As far as my argument that she should have been obviously free to leave and free to get her belongings and leave. And I'll look at the record too. But my understanding was the officers testified that they had discretion whether or not to arrest for driving while suspended. And that's,
And I do think from what they do say that at page 27, that they have that discretion.
and
And can you just provide a citation and an appearance date to the offender? So.
yeah, and if you look at the video, this first officer who initiated the stop was writing the ticket. The second officer was standing on the side of the street with my client and talking with her throughout, kind of trying to explain what they were doing. It is only when the dog hits that they put her in cuffs. So I think the evidence shows that they only were going to arrest her if the dog hit. If they didn't find anything in the car, they were just going to give her a citation and say, have a nice day.
Well, if that's not true, if they decided to exercise their discretion to arrest her simply because they wanted to extend the stop so that they could search the car for drugs, is there a problem with that? Is there a constitutional problem with the way or the reasons they exercised that discretion?
Under case law, as far as officers exercising discretion, whether or not it be you have the discretion to arrest this person for crime X or let them go on a citation. I think the case law would be that's up to the officer. And if they do it to extend the stop, we all know this court allows, as well as other courts, allows pretextual stops of cars. So I'm guessing that the case law would say that's fine, whether or not I agree with it or not. But here, I don't think that's the scenario. I think the evidence shows that she was only going to get arrested when the dog hit.
I want to make sure my notes are comport with your recollection. I've got the K-9 arriving at the scene at 4:51 PM. And an officer Bailey completes the citation and steps out of the car 40 seconds later. Does that fit with your
That's my
recollection?
understanding of the record.
Okay.
Yeah.
And that's why I'm saying the timing on this thing is so tight.
It is very tight. My recollection of the record is that the drug dog arrives at 4:51, as you mentioned. Officer Bailey testified that he was done with that citation, gets out of the car roughly 40 seconds later, confers with the K-9 officer. They then do the runaround of the car, and the dog hits on the car at 4:55. While that is not a huge amount of time, I would point out in Jimenez, I'm not sure how it's said. The entire traffic stop, I think, was like 7-ish minutes. And part of that traffic stop involved the officer asking a bunch of travel questions, which this court said immeasurably extended the stop, and that was improper. So it's not the amount of time, it's that it was extended. You don't get to violate the Constitution a little bit. You either do or you don't. And for that reason, we believe there was a violation here, and we would ask that this court reverse the Court of Appeals and also the district court on that matter. Thank you.
May it please the court, Assistant District Attorney, on behalf of the state. It's our position here that the Court of Appeals got it right. We are talking about 3 minutes and 20 seconds.
There's no de minimis exception to our case law that says you don't extend a traffic stop beyond the time needed to complete that stop, right?
Correct.
So
However, it does say measurably extend. So it's our position, the facts here in this case, this stop was not measurably extended.
and is there any authority that has defined measurably as anything other than the time needed to complete the processing of the basis for the stop?
Not that I discovered. We have not.
But that's an argument you're making here.
Correct,
Okay.
correct. That in this situation, this is not a measurable extension. As the timing is important here, and it's very well set out in the record. Additionally, you have video of the stop, but at 4:51, the K-9 arrived and the officer here was still completing the citation. The purpose of the original stop remained in progress and had yet to be completed. Then he testified that approximately 40 seconds later, he completed the citation, briefly spoke with the K-9 officer, and then the K-9 ran around, did the sniff around the car and indicated at 4:55.
But did he tell her that she was free to go after he handed the citation to her?
I don't recall.
I mean, I don't know of any evidence in here about that.
Right, and I don't recall, because it has been a while since I saw the video, if when he completes that citation, if he goes to her or if he immediately speaks to the K-9 officer before he runs the dog around the car.
And would you agree that a person is seized in a traffic stop from, when the lights go on and they pull her over until she's told she's free to leave?
Yes.
Okay.
Yes. And in here, there's been many conversations about she could have walked away, this and that. She was not handcuffed this whole time. She was on the phone with a friend talking about what was going on, and the video will show that during that time, she also never asked for that person to come and get the car. And that it was at some point, I mean, she knew that she was suspended. She knew that she could not drive. So she knew that she was not going to be driving away in that car. So our position is the Court of Appeals, as I stated, got this correct, and that this 3 minutes and 20 seconds did not measurably extend this stop.
What would be measurable then? I mean, I can measure it. It's a quantity of time.
True. I believe in in this situation, in situations like this, measurably, I think it has to be something, honestly, in the 20+ years that I've been doing this and dealing with dog sniffs and measurably extend, I've never seen one this short. So I think in many cases, there have been some that have been longer than this, and courts have found it to be okay. 3 minutes and 20 seconds, when he has testified that he did nothing to extend the stop. He was not doing anything purposely to extend it to get that drug dog there. He was doing everything he would normally do with a traffic stop.
What is the evidence in the record for that? Because it seems very coincidental to me that he finished writing the ticket contemporaneously with the dog arriving. Do we have anything in the record to show us how long it took him from walking back to his car to write the ticket? I mean, he did not write the ticket, you know, I mean, he was not engaged in writing the ticket because he first called for the dog, right? So
at 4:36, he conducted the traffic stop. At 4:42, he's back in his car. At that time, he confirmed her license was suspended and he requested the K-9 unit. Then the K-9 unit, during that time between him requesting the K-9 unit, determining her license was suspended, he's doing the records checks through Spider. He's checking
right.
for
So there's
warrants.
13 minutes between when
There's
9 minutes. 9 minutes he's writing a ticket. Is there, and you just stated that he wasn't doing anything in that 9 minutes, you know, that is that how long it takes to write a ticket?
Well, I believe he testified, I mean, the record will reflect, he testified as to how long it can normally take to do all of those record checks to
Okay.
write that ticket, because he is not,
Tell me where that is in the record. I didn't
it
see.
would be in his testimony. I would have to,
Okay, that's fine.
yeah, it would be Officer Bailey's testimony.
But none of
Should
that's
reflect
really
that.
relevant, right? Because there's no allegation by the defendant that the officer drug his feet while he's processed. I mean, that could be an issue.
It could be correct.
It's not an issue here.
No, it's not. It's not. And additionally, you do have the district court who weighed his testimony, found the officer credible. There's no question here as to his credibility that the coincidence of him finishing up that ticket. The officer, his testimony was weighed and found credible, and the district court determined that this was not a measurable extension. Alternatively, if you are to find that this 3 minutes and 20 seconds was a measurable extension, it's our position that there was also reasonable suspicion here to justify extending the stop to allow that K-9 to sniff the car. And that goes back all the way from the officers observing defendant stop at a suspected drug house, go inside for 3 to 5 minutes and leave, then following and observing her conduct a traffic violation, and then defendant telling the officer that she was looking at the property to rent that she happened to stop, that they stopped her in front of, and she had simply stopped at a friend's house to ask for directions. The officers testified that their suspicions were heightened due to her explanation of her actions, feeling that it was unusual to stop someone who said they were lost, had stopped at a friend's house and asked for directions, and then just happened to be pulled over directly in front of a house they were looking at.
Did they have knowledge of her prior drug history? In hearing your synopsis, is that a part of the equation also, or when did they know that?
He finds that out when he is doing the record checks, the license checking for warrants. He discovers her prior history of narcotics possession. So that is compound. It's a part of the whole totality of the information that he discovers and has. In addition, he had been doing an investigation on that home, a drug investigation, had done a trash pull the day before and found evidence of narcotics distribution. So putting all of that together, the officer had a reasonable suspicion and was able to articulate a particularized suspicion that defendant was in possession of illegal substances.
Isn't one of, I don't know, what about the officer testimony that they intended to arrest her once she made the admission that she was suspended, and they corroborated that? So I think, as I understood the arguments at the district court level, there was a state statute gave the officer discretion whether to arrest or not. But maybe department policy regulated that discretion. Is that relevant? If state law grants an officer discretion to search, does it matter what the department policy is when we're conducting a Fourth Amendment analysis?
Here, I don't know, and I believe that policy is part of the record. I think it's a defendant's exhibit. But I don't know that it necessarily matters here what their policy was with the driving while suspended. And you're correct. He had discretion to give her a citation and let her walk away, or to arrest her. It is a driving while suspended is arrestable. So I think the defense probably admitted that policy somehow in their argument, but I don't know that it necessarily affects what happened here. I don't know if that answers your question.
I didn't know if it was legally significant, even if the department policy limited that discretion, whether that is a relevant consideration in a Fourth Amendment analysis.
I didn't think about it that way. But I don't know that it is. I think all of the facts, factually looking at this case, I think this was, it was a solid stop. It was a solid search. And we don't have a violation here.
And the basis for your saying that is you think officers, after the seizure ends, have a cushion period to still do a search?
I don't know that they have a cushion period. I mean, we're not saying that they can just.
I mean, there's 3 minutes here. You're trying to say that doesn't measurably extend. I interpret that to mean the officers ought to have at least 3 minutes of a cushion to still keep someone seized and do a search.
I don't know that we're saying that there's a cushion, but again, going back to measurably, we don't feel that what occurred here on the facts of this case, that this was a measurable extension.
I mean, it seems to me if you're saying measurable extension does not equal 3 minutes from, where I sit, that seems like there's at least a 3 minute cushion.
I guess we're saying two different things, or we can agree to disagree, but yeah, it is our position that this is, on the facts of this case, this is not a measurable extension.
So taking that one step further, what would be a measurable extension? I mean, if we were to adopt your argument and say, in this case, the 3 minutes and 40 seconds was not, or 3 minutes and 20 seconds was not measurable. What about 4 minutes and 20 seconds? What if it had been 4 minutes and 20 seconds?
Well, I think you need to look at everything that occurred. I think if you're looking at the officer's actions, once he finishes the citation and he does things purposefully.
But under these facts, what if it was 8 minutes and 20 seconds? Would your argument be different?
Under these facts, I think the important piece is that the dog was already there. I think many times you have situations where the citation is completed and the dog hasn't arrived yet.
Okay, so,
That's the problem.
so if the dog had arrived but took 8 minutes and 20 seconds to, alert, what would your position be? I just want to know if we're going to adopt what you say, when the next case comes, what are we supposed to do?
Well, I don't think this court has to set out a specific time frame. I mean, we do have measurable already in the case law.
Then that's what I'm
think-
asking. What's measurable? Is 8 minutes and 20 seconds under these facts? Is that measurable?
Well, under these facts, we don't have that. That's the problem.
But I'm
If
giving you a
these
hypothetical.
facts-
Yeah, I'm giving you a hypothetical. Everything's the same, except it took 8 minutes and 20 seconds to alert.
Well, I would find it highly unlikely for a dog to take 8 minutes.
I mean, is it a yes or a no? I mean, is that measurable? Is that measurable?
I would say that could be measurable.
What about 6 minutes and 20 seconds?
It would depend on the
No, the exact same facts.
exact same facts.
Yeah.
The problem is here, that is not what happened.
Right, I'm giving
And
you a
I understand you're
hypothetical.
giving me a hypothetical, but it's an unrealistic hypothetical under these facts.
Thank
Let
you.
me try to see whether I can articulate what I think you're saying. These are human endeavors with people who have, there may be terrain differences, there may be, somebody may have a problem with a shoe. It's a human endeavor, both on this, on everyone's side. It is not something where we're in a surgical place where we're making microchips or where we're doing something that does require second to second surgical precision. Is that what you're talking about when you say measurable extension has to take into account all of those human and environmental facts?
I think that is a good explanation and a good description. It is a fluid situation. Now, we are lucky here because we do have these timestamps of what occurred. We also have the video to see what occurred. But yes, you have a number of factors when you are dealing in a situation like this. And I think that's where you're looking, when you look at measurably. I mean, in the state's opinion, 3 minutes and 20 seconds is not a measurable extension. And I don't know how to say that any better than this amount of time does not equate to measurable.
But how do we reconcile that then? Because the case law talks about measurable extension. Measurable is a period of time. So even if all of those human factors, how fast somebody talks, how fast somebody walks, I mean, when he's done, he's done. And so time can be measured. In this case, it was measured.
Mhm. And I would agree with that. And that's why our alternate here is, should this court determine that even 3 minutes and 20 seconds is a measurable extension of this stop, that we also have reasonable suspicion. The officer had reasonable suspicion that there was a possible crime being committed. But I agree, it's very hard to put a finite, because of all of the factors that are in consideration here, to put a finite definition on what this is. And I think it depends on the facts of the cases. And that's why we feel that in this factual situation, this was not measurable.
But isn't a possible reconciliation that we may look at the amount of time it took him to write the ticket and say, is that a reasonable amount of time given all the facts and circumstances? But that it changes once he's done. Once he's done, then we start measuring with precision.
That is possible. If there are no other questions, we would simply ask that you affirm the Court of Appeals and affirm the convictions in this case. Thank you.
Mr. Meharry, you reserve 3 minutes.
Thank you, Your Honor.
Mr. Meharry, before you get started
Sure.
on Ms. Coon's last point on reasonable suspicion, what does it take? Here we have trained law enforcement officers knowing that this driver has a history with drugs, going to a drug house that they're surveilling, stopping. I don't know how you want to characterize the story, but it's maybe an odd story about her presence there, leaves shortly thereafter, coupled with the other things that they learn at the traffic stop. Why isn't that reasonable and objective standard for reasonable suspicion? Or what more is needed?
Sure.
Where are you at with that?
We don't believe it is reasonable suspicion because what you have here is, as you said, they saw her stop at a house. They were surveilling for possible drug activity. Stopped for a short amount of time. What she told the officers was she asked a friend who she named her friend who was the subject of the investigation and said she was simply asking for directions to this rental, which is true. The landlord testified, she told my client, it's on this street. My client not familiar with that area, so she asked a friend who lived in that area for directions. The officers testified, she told us that at the scene. The officers testified that certainly seemed plausible. The officers testified we had no reason not to believe her. Further, her drug history, when the officers pulled it up, it also showed that her drug history was old, from 2010 or before. So what the state wants you to do is just look at certain things. Reasonable suspicion is based on the totality of the circumstances. And when you look at everything here, what you have is a person who's lost, gets directions from a friend, pulls over to the house she's looking at. And I know this wasn't argued below, but I did watch the video and sure, to me, it looks like she's pulling over before those sirens come on, but that's just me. So you have somebody simply driving in a neighborhood to a rental house. And I don't think the fact that she stopped at a friend who's under investigation, simply being in a high crime area or in a drug house in and of itself is not enough. The fact that she has criminal history, which is old, I don't believe even when you marry those two things is not enough for reasonable suspicion. And those are things the officers knew, but they simply chose to ignore when they're talking about their reasonable suspicion. We don't believe it's reasonable suspicion.
Counsel, real quick, would you agree that in order to achieve your ultimate goal of suppressing the drug evidence, you would have to demonstrate that the search of the vehicle was unconstitutional?
I mean, I would say in kind of a roundabout way, in that there was no reason to extend the stop. They measurably extended the stop improperly. And there was
Right, but you
not,
still have to show the search of the vehicle was unconstitutional, right? I mean,
well, I think I have to show that the search was the result of the unconstitutional detention. That the only reason, and this gets into a little bit of the inevitable discovery, the only reason they were able to search was because they measurably extended the stop in violation of my client's constitutional rights.
so you think if they had told her she was free to go, they would not have been able to search the vehicle?
Well,
They would not have been able to perform the drug sniff.
I don't think they necessarily would have had that opportunity.
Is there any evidence in the record that makes that plausible at all?
I think there is evidence that if she would have been able to go, clearly she was frustrated. She was being held there, detained there. I think the evidence is that she would have got her stuff and went.
Well, I went and looked while you were sitting down, and I'll ask you if you agree. My read of the record is that the only evidence about what she would have done is that she would have left. The officers testified she wanted to leave. There's nothing at all about, I mean, even if we enter into that sort of speculative land about her trying to get get the drugs out of the car with the drug dog and the officers there.
Well, I think,
Seems highly,
I mean, to me.
is there any evidence of that?
If you're there and assuming that these, and she all along stated these were prescription. But if you're there and you're free to go and you've got officers there, I think I would grab my stuff and go. I don't think that's out in left field.
Will you
So
remind me, was it found in her where was it found?
if I remember right, it was found in an envelope in the center console of the
In
car.
the center console. Thank you.
I'm pretty sure on the envelope part, and I think on the center console part, Your Honor. So I think, like I said, I think the unconstitutional detention allowed the officer to search, which resulted in finding of the drugs. And without that unlawful, unconstitutional detention, they would not have been able to do that. One thing I did want to point out, Justice Luker, you said, you pointed to volume 4, page 24. That was the testimony of Officer Isham. I don't know if I'm saying that right. But he did talk about whether or not they will arrest for driving while suspended after a pretextual stop. And I'll just quote it. He said, but we had talked about it at some point. If they are suspended, this is a normal circumstance for us on a pretextual stop. If somebody is suspended, they are probably going to go to jail because that does allow us another avenue to get inside the car. So he isn't really talking specifically about this situation, more generally. And if you look at Officer Bailey's, and I'm looking at kind of page 35 through 38-ish, he talks about they have that discretion to arrest. But when you look at how this traffic stop played out, Bailey said to Isham, look, she's got a suspended license. I'm calling a drug dog. They only put her in handcuffs when that drug dog hit. That was the reason why they arrested her. So I don't think they can rely on driving while suspended to keep my client there. If there are no questions, we would again ask this court to reverse the Court of Appeals as well as the district court in this matter. Thank you.
Thank you. Thank you to both attorneys for their arguments in this matter. The court will take this case under advisement.